We're starting now. So thank you everyone for coming. Okay, the time is now. Welcome. Good morning, everyone. Thank you so much for being part of today's seminar, Estate and Legacy Planning, hosted by Heidi Law Office. Welcome to those who are online. Thank you for joining, and those who will be joining soon. We are glad you're all able to make it here this morning. The topic for today is how to avoid the three biggest mistakes in estate planning, hosted by Ivy Law Office. My name is Attorney Jumoke Oladapo. We all welcome you today. We're going to be here for about 2 hours. It's going to be an educational session for the most part, and we'll have questions at the end. So our office is located down the opposite, over there, over there, 6305 Ivy Lane, Suite 500. And we do immigration law and estate planning, and those are our focus areas. Today it's about estate planning, and we hope that you will gain a lot and your time will be worthwhile this morning. The best way to make use of your time is to please turn off your phone or to put it on silent, because you deserve this time for just yourself, and not only yourself, but also for your loved ones. All right. A few housekeeping. Today it's an educative session, and we'll be taking questions at the end. Please, when we're interacting or when we're taking questions, don't give a lot of personal information, because we're streaming live, and after that it's going to go on YouTube and Facebook. And if you give too much personal information, then people will know who is speaking. So you can ask your question, but you know what to do. Also, this forum does not create an attorney-client relationship. We will become your attorney once you sign the dotted line called legal representative agreement or engagement agreement. But so far, we just appreciate that you're here, and we'll be able to help you. Questions will be at the end of the presentation. Also, in your folder, everybody should have a folder, a blue folder. In that folder, we have a green worksheet. This is going to be used as a form of interaction today. Would like you to please complete the worksheet. The first part is contact information. All the information you give to us will be treated as confidential. It's not going for public use. Also, in the second section of that worksheet, during the meeting, I'll be asking questions or saying something like, if you want to keep your family out of court and conflict, if this resonates with you, please check that box. Or if you want to create a live-in trust or review your estate plan, please check that box. So that second section is what you will check as we go on during the presentation. And the third section has to deal with next steps. The next step will include inviting you for a strategy session called the Family Wealth Planning Session. And at the Family Wealth Planning Session, it's a one-to-one meeting with you and your loved ones, and we will be asking and digging deeper into your specific situation and your need for estate plans. And once we have that, we can go ahead. We'll learn more about that. Also, if there's a need for a follow-up appointment, or if you'd like to have an electronic copy of this estate and legacy planning book, you check the box. Or if you'd like to be getting our e-newsletter, you also check the box. And also you can tell us how we can serve you better or how you found this seminar today. The next slide talks about golden tickets, and we really appreciate the fact that you came here today. So we'll be giving you some gifts, and the gift is going to be in form of a gift certificate. The first one will be a $750 gift certificate to enable you come for a family wealth planning session. A family wealth planning session is valued at $750, but because you came, if at the end of the presentation you submit this green worksheet, we'll give that to you so that you don't have to pay for the session, or you don't have to pay $750 for the session. For those online too, you can just say, I'm here with the first name, and we will honor that when you call our office. So at the end of today's meeting, submit your green worksheet, and we'll give you a $750 gift card or gift certificate specific to the family wealth planning session. Also, if you stay tuned to the end, we have additional gifts, as well as, more importantly, if you sign up for a family wealth planning session, then we'll give you an extra $250 credit gift certificate that you can apply to any plan you choose if you engage our services. So we'll really appreciate that. And in addition, we're going to give what we call an digital asset checklist. So one thing we find out is that a lot of people have a lot of things online. Am I right? Do you have a lot of usernames and passwords like I do?
Yes.
I have plenty.
Yeah, plenty.
Mm-hmm.
It's somehow very difficult to know every time. A lot of times I see myself doing forgot password, because I don't even know what it is. But for the purpose of estate planning, it's even more important because when people are gone and they can, and no other person really knows what your username is or your password, then it becomes difficult for them to access what you have. So this will help you coordinate what your digital assets are, and you'll be able to manage that as part of your estate planning. So we'll want you to make the best use of those gifts that we'll be giving out today, which you'll all have at the end of the session. So please stay tuned to the end. We'll appreciate that. So my name is Attorney Jumoke. Again, our office is called Ivy Law Office. We've been serving our communities for 13 years as attorneys, both in immigration law and also estate planning. Those are our two areas of focus, and we are experts at both. So over the years, we've been blessed with a lot of accolades, which we don't take for granted, but we have because people recognize what we do, and we were nominated and chosen for some. So these are some of the accolades that we have. Lawyers of distinction in Maryland. We've been named the top 10 law firm in Maryland for immigration law, the top 10 attorneys as well. We have a lot of Google reviews, and they're 5-star reviews. We have a lot of them, and they don't come cheap. And ours are not the ones you do with, what's it called? They're not bought. I don't know if people buy it, but they are real testimonials of satisfied clients. We've been named top attorney on AVO, and also specific to estate planning, we licensed as personal family lawyers, and family lawyers means we represent your family when it comes to estate planning, and we are trained to serve our clients with excellence. So for us, estate planning is not a transaction. Estate planning is really about serving our clients, knowing them, creating a relationship with them, and giving so much value to the services we offer them. So we see estate plan as not a one-time fix-it-all, because sometimes, or a lot of times, people's life will change, the law will change, and we'll find out more about that later. So we want you to see us as a trusted estate planning attorney. Um, for us, family matters, and that's my family. I'm married. I have 3 kids. One of them graduated with a BSc yesterday, so I'm glad about that.
I saw that on Facebook.
You saw it on Facebook, okay?
And I said, congratulations, daughter.
Thank you. Yes, I saw your comment. I appreciate it. So this was when she was leaving high school. Right now, she completed a BSc, and one of them is still a minor child, and one is in college. And for me, what all this brings about is the fact that when we plan, we do it for the people we love most. It may not be just about us, but it's for them. Okay. So along the way, I'm going to ask you about who are you here for, really, and you'll let me know, or you write it down. So we have an excellent team of staff at Ivy Law, and we serve our clients 5-star. So I really appreciate the people that work with us. That's Attorney Wilberforce, that's me. I'm the manager attorney. We have Attorney Wilberforce, we have Miss Moji, and with us today we have Miss Taya, who is right there behind us, and Miss Princess was the one that ushered you in to the building. So thank you so much for coming here today and working with us at Ivy Law. You really appreciate it. All righty. I want to know, before we go into the matter of today, how you found out about us and decided to come today. So Facebook. Thank you so much for honoring that invitation, even though you knew from Facebook. Are you one of our followers?
No,
No,
it was just an ad.
It was an ad. Thank you so much for coming. We really appreciate it. Thank you so much for coming with that. All righty. And how did you find out about us?
We have known you for ages.
Yeah.
From church to family to,
So it's a personal invitation.
Well, my wife told me to come here.
Well, we've known you for a long time, but then I guess doing estate planning was something on my mind, and then I saw your flyer at my client's house at a listing that I had.
Yeah. So we did this flyer.
Yeah.
And she's sorry. So thank you for honoring our invitation and coming today. It's going to be worth your time. Okay. So this is a question that I have for all of us. Do you currently have an estate plan? No.
And the plan is between us that when anything happens to us, which is that now, and I become 95 years or 100 years old, I would have enjoyed my money before those children need to also work for themselves. That's how we send it.
So you have like a verbal or oral plan.
We don't have anything.
So you want to give all my property to
So a lot of us have plans in our mind, we have an idea. Some people don't even want to think about it for a long time. And for those who are online, we want you to engage as well. Please put in your chat or type in the chat how you found out about us. Welcome. And also, if you have an estate plan, please say yes. And if you don't have, say no. We want you to participate as best as possible. So when we talk about estate plan, it's about, welcome, ma'am. It's about having a will or a trust or powers of attorneys and things like that. Some people think it's about real estate, but it's not necessarily about buying a house or selling a house. So I find that some people don't understand it. The real estate is different from estate planning. When you have a real estate, then you need to plan for that real estate that you have. in addition to your loved ones. So we want to make it as simple as possible. So I'm going to start from estate planning 101 this morning so that we'll all understand the basics, then we move up there. So if you don't have a plan, these are some reasons why some people don't have a plan. I want to see if our reasons probably fall into any of this category, and if it doesn't fall into it, you can say your own why. You're welcome. So, do you have a plan in place
I
already?
do not.
You do not? Okay. So, if not, why not?
Procrastination.
Yeah, that's basically it.
Procrastination.
Mhm.
Okay. How about you?
I agree.
You agree? Yeah. So, procrastination definitely falls into this. I'm too busy
Too young.
or too young because you want to get to 95 and probably
Yes.
still in the middle.
Mhm.
So you have a long way to go. So, some people just think at the back of their mind that maybe it's too expensive. There's some assumptions that we just make. But what I realize is that not having something in place is going to be more expensive than if you have in place. So it's not never too expensive to have a plan, estate plan in place. All right, and for those who have, um, none of us in the room, is there anyone on the chat that is putting a comment? A lot. Oh, put it back in never. I thought I did. So for those who have, it's like maybe they came to have a better understanding about estate planning. Give me 1 minute. You don't have to put it in there, but just like a better understanding about estate planning. Of course, all of you will do today. And also, some people probably prepared their plans on LegalZoom, online, Rocket Lawyer, Susie Oman, different online tools. And you know something about those online tools? When they finish preparing for you, they'll say, take it to a lawyer. So I'm now like, so why do you have to prepare it in the first place when they're still going back to a lawyer to review it for that? But anyway, and some people had their plans a very, very long time ago and it's outdated. And as I mentioned earlier, if you have an outdated plan, it may not work for you. So in estate planning, you need to review your plans from time to time, and we'll talk about that more. So, big fear. Is there anybody with any fear or any myth about estate planning in the room?
Any fear?
Fear, F-E-A-R. I mean, some people don't want to put a plan in place because they think planning for it will hasten the occurrence of passing away. And I know that is some of the things people have where I come from in Africa. They think when they plan, they're gonna, but that's not really it. Because you plan by having something similar, you have a car insurance. It doesn't mean that your car is gonna have an accident the next week. And you have a life, a lot of people don't even have a life insurance. You have homeowners insurance because you're forced to have it, but it doesn't mean that your home is going to burn down the next day, So when you want to put a plan in place, it's not because you're going to pass away the next month, it's because you want to do the right thing for your loved ones and not create a mess for your loved ones. So these are some other things. I'm too old. I still have plenty of time. We spoke about that. Some people think it's for the old folks. And do you know why? That resonates because a lot of people that want to plan, I see a lot of people in their almost retiring age, 60 and above come in more to say we want to have a plan done than people in the middle age, you know. And that's because they think it's for the retired folks or the old folks. But that's not true. That's not correct. Okay, so if you know some young people that are over 18 and they're out of college and they've started having a family or started having some form of asset, like a car, like a house, that's the right time to put a plan in place. Okay, so it's not for the retired folks, it's not for the people in their late 50s, it's for everybody 18 and up, or probably in the mid 30s to be, more reasonable. Some people think they don't have enough. How many people think, I don't really have a lot of stuff, so I just have a house. That's it. Is there anybody that thinks about that? I hear that too. Honestly, some people say, "Oh, I just need a will, nothing much, I just have a car and I have a house, and that's it. And I just want something simple from me to my children." And by the time we sit down with them, I'll find out that their life is not as simple as they think it is. They have a lot of backups behind that simple statement. So, but enough is not really the answer. Everybody has something. You don't have to be wealthy to have a plan in place. If you have something, those who say they have just a house have something. And we'll find out more about the some things that we need to have, or the stuff that we need to have that constitute an estate that qualifies us to have an estate plan done. Some other people think a will resolves everything. The most popular estate planning document is a will. Am I right? So when you hear people say, I want to have a will done, they think that's the answer or the solution. But today you're going to learn that a will may not even be enough. Some people, it's okay, it may be enough, but for some, a will is not enough. And you need to do the best thing for your loved one so that you don't leave a mess thinking you've done something right, but it's not complete, it's not okay. Do you understand? So you learn a lot today about that. So, coming here today, you'll have the total assurance and comfort and the peace of mind of knowing that your family will be taken care of the way you want, not the way the government wants if something happens to you. Also, you will know how to have the peace of mind of knowing that your assets go to the people you want without most of it going to government and taxes. And for those who want to save on taxes, honestly, we get taxed a lot. Income tax, sales tax, what other tax? Property tax, recognition tax.
Car taxes.
Car.
When you your car, you pay taxes.
You pay taxes for almost everything. 401k to get taxed. A whole lot of taxes. At the end of the day, it's like, I think we're living for the government and taxes, but you may not be able to totally avoid these taxes, but at least you want to minimize. Am I right?
Yes.
So if you want to minimize taxes, then you want to find that out by having your plan done the right way to minimize those taxes. And for estate plan, we have probate tax, inheritance tax, estate tax. You taxed while you're alive, and when you're gone, you'll still be taxed. So do it right, at least to minimize those taxes. Also, estate planning is not just about planning for death, okay? It's also about planning for life while you're still alive. In the event of incapacity, what do you want to happen to you? Who do you want to take care of you? If you are someone who cares about your self-care, who cares about who you want to make decisions for you in the event of incapacity, if you want to make choices by yourself and you want your choice to be honored by the people you choose and not by who the judge chooses, then you need to put a plan in place. So estate planning is beyond, it includes in the event of incapacity. And legal documents like power of attorneys and healthcare directives are relevant when it comes to this. Don't take those documents, legal documents, lightly, okay? Because they do wonders. So, for example, if you have, I have a situation of someone that came and I saw the person probably a month ago and it was cool. It was alive, well, doing okay. And a month after, the wife called me and said she wants a power of attorney. I said, okay, right. Said she wants a power of attorney for her husband. I said, okay, what's going on? Because why wouldn't the husband call alongside you? And she said, oh, my husband woke up, he got a stroke, and also not too long after that, he just began to have a new, what's it called, dementia. So he started losing his memory. So, well, I'm like, I hope it's not too late at this point. Because when someone begins to have Alzheimer or dementia, you can't sign those legal instruments if you don't understand what you're doing. So it's better you get them done while you have sound mind and not wait for when it's too late. So you want your wishes to be honored and you want to get them done on time. And it's also important for our children. So for me, I have college age students when they were going to college, they signed, I prepared a medical power of attorney. Okay. So I know that they have this form in the school that says you're in college now, so if you don't want your parents to have access to your records and all that, a medical decision, you can block your parents out. So before they left, I was like, you make me power of attorney for you, just in case you become sick and the school says, oh, you can't make decisions for her. I have something as a backup to say, hey, I have the authority to make decisions for you right now. I also have the authority to check your results too. So plan ahead for those who have like mid-age children so that you'll be able to at least make some decisions for them if there's a need to do that. All right. Estate planning is also about protecting an asset from being lost to the state. All right. A lot of people don't catch this, but a lot of assets gets lost to the government because people don't plan. And those assets that easily gets lost to the Department of Unclaimed Properties. You have 5 bank accounts. Your spouse knows about 3. The other 2 have, they're probably savings or money markets that generated money from you for you, but somehow you didn't really want your loved ones or your spouse to know about it. If something happens to you, it's those 3 accounts that they know about that they'll look out for. Am I right? Mm-hmm. The other 2 will be lost to the government after 3 years because nobody knows about it that knows you. So, as part of our planning, we help our clients marshal together their assets and we prepare a family wealth inventory for them so that during the planning session, they are able to at least put down what they have. And if something happens to them, their loved ones will know what they have, where to find it. We want to take questions at the end of the session, if you don't mind. But we have a piece of paper in your folder. You can jot down the question, and we'll take everything at the end. I want to save time so that we'll have enough room for questions, if you don't mind. Is that okay? Thank you. So please jot down your questions on a piece of paper, and we'll take everything at the end. Even if I've already answered it, someone else may benefit from it, okay? So if you want to have comfort and peace of mind that your families and assets will be well taken care of the way you want in the event of incapacity or death, and your choices are honored, then you want to have an estate plan in place. But more importantly, you are here for the right reason. Do I have someone who is here for the right reason? Alrighty, thank you. So we're at a point now where we'll start using our green worksheet. I hope we filled out our names on the green worksheet and contact information. They're confidential. So what is estate planning? Estate planning is planning in advance and naming who you want to receive the things you own after you die. But estate planning is not just that. That's the popular meaning I can give for estate planning. And a good estate planning is so much more than that. And from the summary I've done, from the summary that we did this morning, you probably know that a good estate planning is more than planning for death. Am I right? Yeah. So please let's make it let's give me feedback, okay? Thank you. So a question that you may wonder is, do you really have a plan or do you have an estate? You know, we said estate planning. All of us know the meaning of planning, am I right? But now, estate. What constitutes an estate? What? Everybody has one. Everybody has an estate, okay? Even if you're young, if you're 18, if you're 21, you have an estate. And your estate consists of the following. So tell me, if you have a car, do you have a car? Just say yes. Do you have a car?
Yes. Yes.
Do you have a home?
Yes.
Do you have furniture in your home?
Yes.
Do you have life insurance?
Yes.
Yes.
Do you have a checking account or a saving account?
Plenty.
Yes.
Do you have investment accounts or investment real properties?
Yes.
The real properties. Do you have jewelries, earrings, shoes?
My wife has a lot.
Okay. Do you have artwork?
No.
Maybe
Yeah.
no. Do you have china wares at home?
No.
Do you have
Furs.
furs? Yeah, clothing.
Not there yet.
For clothing. Do you have clothing and shoes
I have plenty.
and bags?
Yes.
The Coach,
Yes.
the Louis Vuitton, maybe not.
Gucci.
The Gucci, the Gucci. Do you have maybe one or two? Or the M&K? What's the Michael Kors?
Yes.
You have the. You even have yours there. You know, and which other one? I think that one is good. We have some of those things, am I right? Or even a lot of them we can identify with. And if you have any one of these things, yes, you have an estate. Okay. So do we see that almost everybody has an estate? Almost everybody, if not everybody, no matter how large or how modest it is. So if you have an estate, then you need to be planning. Okay? You need to be planning for it. A lot of us work very hard and we accumulate things, for ourselves, for our children. And some of us even that have children say, oh, we're working because of our children. Am I right? But at the end of the day, we work and then we don't put the finishing touches to make sure the children don't fight over what will leave them. So everybody got an estate, large or small. In Maryland, a small estate is like, if you have anything, $50,000 and less. And a large estate is over $50,000. Okay. So
In value?
yeah. If you have, well, let me tell you, if you have what?
Like taxable?
They're all going to be taxable. Most of them are taxable, and we'll see what all this, all these things constitute estates. So let's say you have a car, and your car is 25,000, and that's the only thing you have, and most likely not. Then that's a small estate, okay? But let's say you have a home. Most homes are like $100,000, $150,000 up. Am I right? That means you have a large estate.
Where is that?
The homes,
I'm just saying.
maybe a condo, maybe a condo, an apartment is 150, but it could be more by now. Now it's more than that. Okay.
There are
So-
some that sell for 1 million in DC.
300.
300 really? Oh my. I'm out of market then. Okay, so you see that most of the people that have homes have large estates. Okay. If you don't have a home and you rent, more likely than not, you still have a large estate. But a lot of people have small estates. But even if you have small estates, it still takes you through the probate system, so you need to have a plan in place. So earlier on, I showed you the picture of my children. I said, those are my whys. That's part of why we plan. So for you, who needs your protection or what needs your protection? We've spoken about all those things. Can you write down in your piece of paper who needs your protection or what needs your protection? It could be your children, it could be your parents, it could be your siblings, it could be your nieces and nephews, it could be your assets, your car, your home, your life insurance, and all that. Unfortunately, life insurance though may go to other people, but the law counts it as part of your estate. Okay, so what needs to be protected? Maybe your 401k, your retirement plan, stocks or bonds. At the end of the presentation, we'll go back to it and see really, we would have learned more. And we'll assure ourselves, does these people or these assets still need my protection? All right. When you plan, are we ready? Wrote down the people that are the things that needs to be protected. All right. So when you plan, I want us to shift from I'm planning for after death, all right, even though it is, to a mindset orientation that I'm also planning for while I'm alive, planning for life, okay? And these are some of the benefits. The all new experience, if you plan right, will provide you with you being able to make informed and empowered decisions about you, your family, your assets. Okay? You are making the decisions when you plan. It's not a lawyer making a decision for you. Do you understand? And a lot of us, our lives are not boilerplate, so we need to be able to have those exceptions to the rules, or there's usually a general rule, there's lots of exceptions. A lot of people have nuances that they need to put in plans. So you'll be making informed and empowered decisions when you plan. Also, when you plan, you'll be saving your family thousands of dollars. Okay? If you plan right, you'll be saving your family thousands of dollars. Then your asset is not going to be lost upon death. We spoke about that already. Also, you'll protect your family dollars from outsiders. Okay? And you know who the outsiders are? The creditors and the predators. They're out there. They want to prey on what you have. Why? Because probate is public. Okay? So there's some people who earn a living by going to the probate court and looking at the list of the people that passed away and the list of the beneficiaries and the wills that are on public record, then going to sell products to the beneficiaries or the personal representatives. Do you understand? So as much as possible, you want to conserve your family assets or preserve your family assets so that your beneficiaries are getting the most out of it. Also, you have a lifetime of right legal and financial choices because estate planning with us in our office or with a good estate planning attorney should not be a one-time forget about it situation, but it should be such that when something new comes, so for example, you used to live in a house, now you want to either downsize or upsize. You want to know how does that affect the plan that I made. Do you understand? You used to have children under 18. Now they're grown and they're all over 18. There should be a change in your plan. Or there should be, yeah, because probably you had guardians when they were young, but now they're adults. They don't need guardians anymore. Or maybe the people you put as their guardians are no longer in good terms with you. You get what I'm saying? So you'll need assistance of someone that can help you make those choices in form of an expert attorney. And also, you want to keep your family out of court and out of conflict. If you have choices to make, you make it while you're alive. So if they give you an option, oh, I want my assets and my family to go through the court system, or they don't have to go through the court system to distribute my assets. Which one will you choose?
No court.
No court. Will you choose court or no court? No court. So I want us to know today that we have choices, okay? So if you want to choose no court, then you have to do it the no court way by yourself. Because if you do nothing, you'll end up in court. And if you do it wrong too, you'll end up in court. All right. So, but ultimately, we want your plan to work for when it's needed, for your family when they need it. And that's because some people even have plans, but because they don't update their plans or they don't review their plans, it doesn't work when needed. Okay. So, no one in the room has a plan in place. Okay. But a situation that happened that made me write this question is this. When was the last time you reviewed your plan? And if you ask someone, they'll say, hey, 15 years ago. I've even seen a win last of 25 years ago. I was now like, do you think that same plan you had 25 years ago when you just got married will work for you now? You got married, children. Your children are probably even grown. You understand? The plan is not going to work. And there's an example of a woman that did just that. In the 90s, she made a will. Okay, she had a will, and then she had three assets: two houses, one primary residence, one rental property, and a bank account. Okay, so she had that three properties when she was preparing this will, and she prepared the will. Okay, so she kept it in her shelf. Years passed by. By the time she passed away, 15 years later, the children were able to retrieve the will. But by the time they read the contents of the will, because she made specific distributions in the will, one house to one child, the second house to the second child, and the third bank account to the third child. At the time of death, there was no bank account anymore. There was no rental property anymore. The only property that was left was the house, the primary residence. So because she gave specific distributions, only one child that she willed the house to could get it. So what's going to happen to the other two children? They're left out. So she disinherited them because she did not review her estate plan. Do you understand? So we don't just put it there and forget about it. Now, that caused a lot of conflict for our children because the person that she chose as a personal representative was the person she gave a bank account to. Now, he didn't want to act as a personal representative because he wasn't going to get anything. And because the person, the child that had the home, was not willing to sell the home and share the money, she wanted to leave him there. So there was a lot of court involved. There was a lot of conflict involved. But is that what the mom wanted? Was that what she wanted? Probably not. Do you understand? So we have to review our estate plans, and we recommend at least every 3 years because the law may change, your assets may change, even your beneficiaries or the people you choose as agents may change. Do you understand? I know of someone that says she had an agent when she prepared a will or a plan, a power of attorney, but 5 years later, she wasn't in good terms with that agent. Do you understand? So she didn't want her to be a power of attorney anymore. So she had to make a change. And that was the only person she chose in that power of attorney. So, do we understand that concept? So, for those of us that don't have a plan, what is the state's plan for you? If you don't have a plan, the state has a plan for you. It's not about post Sarah. And do you think the state's plan for you is what you would like? No. They have a backup plan for those who don't plan. All right. And this is a plan that the state has. All right. The state's plan for you is a court process called guardianship or probate. In the event of incapacity, it's called you go to the guardianship court in Maryland. All right. That means you have to file a petition to become the guardian of an incapacitated person. If it's not you that became incapacitated, or a loved one files a petition for you to become your guardian over your assets or the guardian over your person. All right. If you don't have a power of attorney in place or a healthcare directive, that's what's going to happen. And do you think it's a smooth process? No. You first have to wait for the time of the court, for the court to call you. In Maryland, it could be as much as 3 months wait time before you get a date before the judge. And now it becomes more complicated if there are two people who are interested in you or in your money. And you know what? These loved ones both love you, but they don't trust each other. Or one person thinks he can do it better than the other person. And they come before the judge, you make a case, she makes a case, and the judge will have to decide who will be your guardian or who will be the guardian. And you know, some people are not there for the right motives as well. Some people are really caring and they want to take care of you, but for so long. Some people are really after your money.
Mm-hmm.
And a lot of people are really after the money. Do you understand? So you want to choose someone that you know, like, and trust by yourself before you have a need for a power of attorney. Otherwise, the judge will have to make a decision about who will be the agent. Do you understand? And you know, sometimes the judge will not choose the two people. The judge is going to choose a lawyer.
Mm-hmm.
Yeah. A third disinterested or uninterested person to manage that person's asset. Is that what you really want?
No.
So, this happened to someone before. The dad, let's call the dad Mr. Barber. Mr. B-A-B-A. He became incapacitated because he had an accident. And he couldn't really take care of himself. He couldn't pay his bills by himself. He was stuck in the hospital. At some point, he has a son that is willing to take care of him. Okay? So the son had to petition the court because when it comes to things like signing a check then, we don't sign a check that much now, or going to Medicaid and speaking with the government about government assistance to help him with the bills and all that. He couldn't do that because it's not authorized to do that. He needed a legal authorization, which he didn't have. So he had to go to the court, and the court needed to appoint him as the guardian over the debt's person and the guardian over his assets for him to be able to help him pay his bills or help him speak with Medicaid and get this benefit and so on and so on. So he went to court because it didn't have a good financial credibility. Okay, the judge did not choose him, and also an uncle came up and said the uncle too wanted to be the personal representative, but the uncle too had like drug issues, and when the two people fighting, you bring out the dirty laundries. So the uncle cannot be the guardian, the son cannot be the guardian. So the judge choose an attorney to be the guardian, and the attorney will now choose someone to be taking care of that person. So let's say the person that was chosen is a nurse that has CNA that comes to take care of him at home. So from that asset, he has to pay the CNA person. Do you understand?
He's gonna pay the lawyer too from the asset.
And he's going to be paying the lawyer. And every time the lawyer does any job for him, like looks into the account or pays his bill or appears in court, the lawyer was going to be charging $200 an hour. Tell me how long, if that man had $100,000 in assets, how long is it going to take to depreciate that?
It's
Probably a year. And do you know what the lawyer did afterwards? Because they had to get his fees. He's not the only one that will come to court. He will bring his associates along. And what?
There's more money.
That's for more money, yeah. Towards the end, when he saw that there wasn't enough money anymore, that lawyer told that guy to get out of where he was living, to go into a less expensive house apartment to afford his fees. Do you understand? So at the end of the day, this man was not living in the good places used to, because the man wants to sell or wants to sell the house or not pay so much rent where he lives, and he'll pay less rent, less better environment, less environment that is healthy, and the lawyer afford his fees. And at the end of the day, all the money will depreciate, and the child will not have anything. So, when you say 1, 2, 3, 4 to 10, when you say number 6, what is behind 6 is more than 7. Do you understand that a lot of effect if you don't make a wise decision? And we're asking you today to make a wise decision. All right? Don't have to go through a guardianship court. You can avoid that habit by having a power of attorney in place right now. It's like an insurance policy. You may not need it, but when you need it, it's there. Do you understand? So that's the guardianship process. And when someone passes away, they go through the probate process, the court process called probate. Okay? So the same issues, the same kind of stories. A loved one will have to go to the probate court and say, this person has passed away. And when they get to the court will say, what does she have? And then they'll say, she got a home, she has furniture in her home, she has clothes, she has 2 bank accounts. And of course, you wonder why they're asking, but they're asking because they want to tax you. All right? So these are some of the fees that goes into the probate process. If you have an attorney, the attorney will get some fees. All right? And in Maryland, the attorney's fees could be almost up to 40%.
What?
Yeah. And that's for lack of planning. So like 37 there. But I know someone that had a $1 million plot of land. And by the time he passed away and they wanted to sell the land, the attorney's fee was like $37,000. But because he did some extra things, he had to get more money from the court and was taking out $40,000. I'm sorry if I said 40%, but
That should be more.
no, that's going to be more, like four.
Like $400 and some dollars. Yeah.
Yeah. The personal representative is going to get some money, which is by law 3%, if they want. Okay, so if the person has done a lot of work, they're entitled to 3% of the assets, estate. Then, if you have a home, you have to have appraisal fees. Bonds, you get bonded. The personal representative needs to pay a bond fee. If you have creditors, they need to be paid. The court fees are there. And all those fees will have to be taken out before the beneficiaries are given the rest. So at the end of the day, what's going to be left? The drops. Not much. Not much at all. So in a family wealth planning session, we look at everything you have and we do an illustration for you. This is what it's going to cost you if you don't plan. Is that what you want? If the answer is yes, we'll make a recommendation for you. If the answer is no, we'll make a better recommendation for you. But you don't know until you know. Do you understand? So at the end of the day, going through probate is like filing a lawsuit against yourself with your own money for the benefit of the creditors, because the creditors will take their money before your beneficiary takes their share. Do you understand?
So you're filing a lawsuit against yourself?
Yeah. So, any person that passes away, their matter will have to be taken to the probate court before title can pass. So, they may be driving the car, but the car is not going to be the beneficiaries. They can't get title that way without the court's involvement if they don't have the right estate planning instrument in place. Okay?
And you said the power of attorney is someone you know, like, and trust?
That's my definition. Because that person is supposed to be representing you. So you have to know the person. Am I right? You have to trust the person too. Because you want the person to act on what you want, not what they want. Alrighty. So Maryland probate is public. I've told you about that. The court process, you can go there and look for someone's will and know what they're giving out or what they're not giving out. Also, it takes between 12 and 24 months to probate a matter in Maryland. So that means the beneficiaries may have to wait that long before they get what you gave. And thirdly, the cost of probate is very high from what we saw in the last slide. Do you understand? In Maryland, it could cost almost 5% of the value of your estate. So if you have an opportunity to avoid probate, please do. Okay? And today, part of what we're going to be telling you is that you have an opportunity to avoid probate. In Maryland, if you have a will, okay, a will takes you through probate. Just having an instrument called last will and testament is inviting yourself to probate court, because the judge will have to make it valid and do whatever you say in your will. It's okay. It's better than having nothing. Do you understand? But also, if you don't have any will, that means the person passed away intestate. The law has the provisions on how what percentage each person will get. So let's say, for example, a person has a spouse and they have adult children. There's a percentage that will go to the spouse. There's a percentage that will go to the adult children. Do you understand? So the law knows how to distribute your asset if you don't distribute it by yourself in a will. So let's say, for example, there's a child that you don't want to give something to because they've been a bad child. They'll automatically get something because you didn't have a plan. But I've seen parents that have come to me before and say, I don't want to give this child anything. Do you understand? I know their reasons. They know their reasons. But then if they don't have a plan, sorry, that's not going to happen. And these are popular people that did not have their plans properly done or did not even have a plan at all. We heard about Aretha Franklin, am I right? We heard about Chadwick Boseman. He probably had some things, but maybe he didn't fund his trust. And we're going to talk about that too. And John Lennon, and that's the will for Jackie Kennedy Onassis. These people we think they should know better, am I right? But it seems as if they did not know better. But we are here, we have an opportunity to know better and do better. Please, let's do. All right, I'm going to talk about some of the consequences of going through probate or just having a will, okay? A will is a legal instrument that you use to nominate who will act on your behalf after you pass away and also distribute your assets, okay? If you pass away without a will, your things go through the probate court and the court is going to be making decisions for you. We know a lot of people fight about who will be personal representatives or executors. Why? Because somebody does not pass away with a will. Now, maybe a spouse is fighting a sibling, or a child is fighting a parent because the mother did not choose who she wants to be a personal representative. A lot of people think by default it's supposed to be a spouse. Am I right? Mm-hmm. What if the spouse is incapacitated and cannot take care of herself or himself?
The court would choose someone else.
The court will choose. Do you understand? So there's not necessarily a default if you don't choose someone by yourself. So I've seen situations where someone, a sibling was fighting, a brother sibling was fighting a spouse. But the spouse was not an official spouse. The spouse was someone like a partner, a life partner. They were not married. Do you understand? Both of them wanted to be the personal representative. But at the end of the day, they said all the woes and all that before the court, and the judge has to choose someone. And do you know who the judge chose?
A lawyer.
Exactly. So, but these are some of the things that we experience when it comes to just having a will. I said earlier, just having a will will take you to the probate court. Am I right? Also, if you have just a will, beneficiaries will receive their asset outrightly and unprotected. And what does that mean? You see these young kids here? They're teenagers. They're still under 18. Let's say the parent passed away and they were 15 years old. And you know what happened after the parents passed away? They were living in Maryland and they were traveling to Florida. A lot of people like going to Florida and they decided to take their car. They had a car accident on the way, almost in Florida. The two people in front, the parents, both of them passed away. but the children survived. Okay? So, of course, they lived in Maryland, they had a home and all that. First of all, they were under 18. So they were so limited. They could think, they could reason, but they're not yet adults. So they need a guardian to take care of them. So one auntie came up to say, "Oh, I'm the aunt. I'll take care of you guys." But do you know what the aunt was really after? The money. Because the aunt did not allow them to interact with other family members and kept them away from the family members. So they were wondering what's going on with these children and all that. So they had to file in court so that she would be their guardian. Okay? So at the end of the day, we found a will. A will was found, and of course, in the will, the parents had life insurance. Let's say the life insurance is $500,000. Do you know that the kids will not get the $500,000 until they become 18? They need someone to manage it for them. Am I right? So they can't get it. But when they become 18 years old, you know what will happen?
Maybe a lump sum.
They're going to get the lump sum. You got it. So he's going to get 250 and she's going to get 250. Both of them are beneficiaries. Or if the parents did not even put a beneficiary, it's going to go through the probate system and the court will share it out because they're probably the next of kin or the next level of individuals who are going to be beneficiaries. So what do you think he's going to do with his $250,000?
Get women.
What? Miami, go back to Miami. Maybe he's afraid of Miami now because his parents passed away while they were going to Florida. Maybe California. Girlfriends, yeah.
But it might be a car freak spending it on everything.
Yeah, that's red fancy car. Any other person. Okay, what about her? What will she do with us?
Her boyfriend might snatch the money if she's dummy.
She'll get a boyfriend who will help her with the money. And you know what? They decide that they're not going to go through college because, of course, they were dealing with grief. Their parents passed away. They're not able to make right decisions. They don't have financial maturity to know how to invest the money. But they'll get it at 18 years old. Outright. Then it's unprotected as well. Someone said the boyfriend will help us spend the money. Am I right? Yeah. The boyfriend will help us spend the money because it's in our name. And she wants to party and do all the sort of things. And let's say now the boyfriend was nice enough to stay on for 1 year. Okay, we've been doing also, let's get married, and she now gets married at 20 years old. Okay? Maybe she still has $100,000 at 20 years old. But of course, because they were too young and they married in a rush, and maybe she was a little stingy. I don't know. The man decides that I'm not doing anymore, and he seeks for a divorce. And now they still have $100,000 at 21, and now because it's in her name, and at some point she puts it in a joint bank account because she was in love. Now, at the point of divorce, it's a marital property. Okay. So now it's a marital property when they want to share the assets. It's not going to be an uncontested divorce at this point because someone is after money. Am I right? Mm-hmm. It's going to be contested. We have some marital assets. So they're going to share the car. They're going to share the money. And I found people who got married for 2 years and wants to seek alimony. You're right. You're right. You may be seeking alimony because he knows she has $2,000, $100,000 somewhere, and he'll get alimony wants to get alimony for 3 years to stabilize, But the judge is going to share that money between the two of them, and he's going to get 50%. because she's already commingled that money. All right. So, was that what the parents wanted? Who was the beneficiary initially? The child. But now, the new spouse is also a beneficiary. So, we need to plan and protect whatever we're giving our loved ones. So, it's not just about giving them something. We want to make sure that they don't have it when they don't need it. We can even put some form of controls over how they have it. If you have a living trust in place, you can say, oh, she can have part of it when she's 21. She can have part of it when she's 25 or after she finishes college or got a master's degree, and she can have part of it when she's 30. We can help them organize how they get those benefits we're giving to them. We can also protect it in a trust. We can achieve that by protecting those assets in a trust rather than giving it to them outrightly. Okay? Because if it's outright, it's theirs. If it's in a trust, it's not theirs.
So essentially it goes in their name and then,
It's not in their name. It's going to go in a trust name,
no, I'm saying with the will, it goes in their name.
in their name.
And because of that, they're vulnerable to like creditors and
Exactly.
like all those people you're talking about.
Exactly.
Okay.
Exactly. Thank you. So, let's go to our worksheet. All right. The first one says, I want to keep my family out of court. If that's something that you really want to do, can you check that box? And the second one says, I want to make sure that my kids don't inherit money at 18. If that's something that you'd like, please check that box if that resonates with you. The third one says, I want to ensure my children's inheritance is protected from lawsuits and creditors and future divorces, no matter how old they are. If that is something important to you, please check that box. Okay? How many of us have like children under 18? You do? Okay. So probably that's something you want to check the box for. But I'm going to skip this, but these are things that can happen. Do you know that? You know what could happen? Some people will be peaceful, some people will be fighting, some people want to cut their house into two, litigation, the entitled children, the nagging siblings. Do we want all this drama in our lives? No. So we want to plan to avoid a mess. We want to benefit them and not leave them a mess. And avoid conflict as much as possible, okay, by doing the right things. So if you have children and you just have a will, the kids could still be at risk, okay? Usually a lot of wills will have a portion that says nomination of guardians in it. And in that will, you can say who you want to take care of your children when you pass away, if they're still young, all right? However, do you know that somebody will first need to find the will before knowing who the guardian is? Am I right? And that happens when you pass away. But a lot of people don't know about the loophole of if you're still alive in the event of an emergency or incapacity, who will be the guardians for your children? Who will take care of them? So let's say, for example, you go out at night with your spouse. Some of us have date nights from time to time. Am I right? Mm-hmm. We go out and you didn't come back, and your children are still probably 5 down the line. They're not like 15, 16 when they will take care of them, but they're still young. If something happens to both of you, what's going to happen to those kids? They go to grandma. Let's say grandma lives in Virginia, and Virginia is even close. Grandma lives in Minnesota. Do you understand what I'm saying? The police will come and the police will pick up the children and take them to CPS. Is that what you really want to happen? So you want to close that gap by having what we call a kids protection plan or a temporary guardian or temporary guardians or short-term guardians for your children. So that you'll nominate who the short-term guardians are and you'll give them the legal authority to be able to take care of your children in the event of emergencies or in the event of incapacity. Do you understand? So these are people you know, these are people you like, these are people you trust, these are people that are in close proximity to you. So now it's not going to be the mama that lives in Minnesota. It may be a friend that lives 5 minutes away, or it may be a next door neighbor. Do you understand? That you know will take good care of your child or children if something happens to you. So in your home, you'll have that legal document saying this is the person that will take care of my children. They have that legal document, and if a police knocks at the door, someone is in close proximity to help you help them rather than they ending up with the authorities. And we help our families, particularly families with young children, get that together as part of their estate planning packet by preparing what we call a kids protection plan for them. Someone please help me say kids protection plan. Please have it if you have minor children. Or if you're a grandparent and you have children that have minor children, you can get that done. All right? So
You can do that as a grandparent?
no, you should tell your children to get that done.
Okay.
That's what I mean. Thank you for clarifying that. Tell your children to have a kids protection plan for their children, okay? So that we're not leaving loopholes because at that point, passed away. Am I right? And it's only when someone passes away that a will come into effect. Also, we spoke about self-care. So, I'm sorry, before I get that, if you need to name guardians for your children, can you check that box? We spoke about self-care earlier on when I was introducing today's presentation. And it's important that we give directives on how we want to be taken care of in the event of incapacity. All right. I gave some illustrations about people ending up in guardianship court. Am I right? You want to avoid that because if you don't make that decision, your wishes will not be turned into directives. If you don't have a power of attorney or a healthcare directive in place, this is an illustration of someone you may be familiar with that, but her name is called Terry Schiavo. Terry Schiavo was popular in the 90s. She was brain dead. So she was in the hospital and she was on life support. She's been on life support for some time and her husband was tired of that. So her husband wanted her to be taken out of life support, but he didn't have the authority to do that. The parents came up as well and said, no, she shouldn't be taken out of life support. Let's give her some more chance. So both the parents and the husband were conflicting over Terry's life, whether she should be continuing on life support or taken out of life support. They went to the court. Someone sued the other one. They went to the court. That was not resolved. It was appealed. They went to the Court of Appeal. The Court of Appeal did not resolve the issue. They went to the Supreme Court. This took about 10 years. And she had to stay on life support for that long until the Supreme Court made a decision that she should be taken out of life support. Do you know how much money would have gone into that process?
Mm-hmm.
Both for litigation and government hospital bills. So Terry could have prevented such by having an important document called an advanced medical directive or healthcare directive saying, I want my parents to make healthcare decisions for me in the event of incapacity. saying, I want my husband, whoever she chooses, or whatever order she chose. She could have said whether she wanted to be on life support or not in that legal instrument. Such a decision as life support, you could want something, you could want something else. And some people are like, whatever you want, I want. But where what you want is different from what you want, you need to write it down in writing, okay? So that it's clear, and no one is confused. So that you avoid conflict between loved ones and you avoid court, okay? So it's important to have a power of attorney, it's important to have a healthcare directive. A very sensitive decision like a life support should be made by you and not someone else. Some people don't want anything. Do you understand? And some people want to live forever. So make up your mind, have your decisions in place so that people honor your choices and not their own choices, not their own opinion. Okay? So go back to that. If you need to have a power of attorney or a healthcare directive, please check that box. If you want to have one, please check that box. If you already have one and you have to review it, check that box. Now we're going to another type of plan. So far, we've spoken about having a will. We've spoken about having a short-term guardianship document in form of a kids protection plan. We've spoken about having a power of attorney. We've spoken about having a healthcare directive. Am I right? Now we want to talk about having a revocable living trust. Someone say revocable living trust.
Revocable living trust.
Earlier on, a lot of us indicated that if we have the choice, we want to avoid court and probate. Am I right?
Yes.
So if you want to avoid court and probate, the only foolproof way to avoid court is to have a fully funded trust with disability provisions, fully funded living trust, revocable living trust with disability provisions. Now you know that I highlighted that fully funded. Am I right?
Yeah.
Someone please help me say fully funded.
Fully funded.
Because that's the key. So let's say you have a living trust and you prepared it and the lawyer gave it to you and you think you're covered. No. All right. So if you go to a lawyer, a traditional lawyer, to say, oh, I want a trust, prepare me a trust. They'll prepare the trust for you, but they don't know how to do better. You think you have that in you, but it's not going to work when needed because the only way a trust will work when it's needed is when it's fully funded. And what does fully funded mean? Fully funded means you transfer the title of your asset from your personal name to the name of your living trust. Okay? So, how does that work? You know all the properties we spoke about before, all the assets we spoke about before. Am I right?
Yes.
The furniture, the car, all those things. The home, the fur. When you come before an estate planning attorney and you come to our office and say, I want to have a trust done, or you don't even know what you want a lot of times. We take an inventory of everything you got. Do you understand? And we advise you. We'll recommend, I think it's better for you to have a trust, or maybe it's just a will, or you need to have all this and this, or you don't even need this. Do you understand? So when it comes to a trust, the investment account, you'll have to retitle it from your name to the name of your living trust. So let's say the name of my living trust is Ivy Living Trust. Okay? My name is Jumoke, and I have an investment account with Bank of America. I'll go to the bank with the trust documents given to me and say, hey, bank, I just created a trust. Can you change the name of this account to Ivy Living Trust? okay? And the bank will do that. When it comes to a house, and you have to sign a new signature card. So we'll be advising you on what to do to retitle your assets. When it comes to the house, you have a home. Usually, a lot of people have homes and buy the home in their personal names. Am I right? And if you're married, most likely it's a joint titled property. Am I right?
Yes.
So if you're a couple and you bought your home and it's in both names, let me tell you what will happen. If one of you pass away, it's not going to go to probate. Okay? It's going to go to the other person, surviving spouse, automatically. It's going to avoid probate. If you have a joint account, the same thing. It's going to go to the next person automatically. However, if the house is in your name only, right, it's going to go to the name of probate. It's going to go to probate. Okay. Also, a lot of
I
people.
thought state of Maryland don't have that law. Once, even though you don't, as long as you're married, you
They
automatically go to your spouse.
No.
Oh.
Sorry. Sorry about that. So in Maryland, if it's joint, it goes to the surviving spouse. If it's in your name, it goes to probate. Okay? Maryland has that law. I'm not okay yet.
Take your time.
Excuse me. Yeah. Can take 1 minute break. Water. All right, sorry about that. I was drinking water to soothe my chills, and the water gave me some issues. So sorry about that. Can we continue now?
Yes, please.
All righty. So a lot of people don't think about if both people pass away about the same time. All right. What happens if the people on joint title have an accident because they were traveling together and pass away? Is it going to go to a dead spouse? No. The home is not going to go to a dead spouse. The home is going to go to probate. Okay. So when you're having an estate plan with an attorney, you're thinking beyond one person. You're thinking far and wide. What if? What if? What if? So that you're totally covered. All right. So that's the loophole that comes up when it comes to jointly titled properties. That's the loophole. It covers just for one layer. It doesn't cover for other layers of protection. That's why you want a trust and not just leave your asset as a joint asset. You get it? Also, some people that are not married, I've seen a situation where someone has like 3 or 4 people on title and they own it as tenants in common. So let's say someone at 40%, someone at 30%, the third person has 30% interest in the house. If one pass away, it's going to go to, let's say they have children, then now they have 2 children, sharing 40%, 20-20, 30-30. Let's say something happens to the next person, then it just keeps going down, the interest keeps going down until something is done to it. So being jointly titled does not necessarily give your assets full protection. But if you have a trust in place, as long as your assets are not in your personal names and they're in the name of your trust, it avoids probate. You get it? And when it avoids probate, you're going to be saving time because I said probate takes 12 to 24 months. But if you have a living trust, it takes less time. It could take 3 months, it could take 6 months, as fast as the successor trustee, is able to work on your assets. Do you understand? Also, a trust is private, probate is public. So you avoid the predators, the unnecessary creditors, and unnecessary business people by having a private trust, because the court is not going to ask you to publish your trust, but the court honors it. It's not even going to go through the court process. Do you understand? The law honors it. So your distributions are private. They're not publicly distributed through the judge. All right? And also, we've spoken about the public nature. We've spoken about the, the time. Am I right? And the third thing is the cost. You're saving a lot of cost because all these people that takes their piece of the pie of the cake may not have an opportunity to do that. Do you understand? And you're saving a whole lot of your family's wealth and preserving that by having a trust, a living trust in place, rather than allowing a will to take your assets to the court. You understand? But the only way it's going to work is when you have a fully funded living trust. I know of a man that prepared a trust. He tried to do something right and he paid $3,000 then to prepare a trust. He remarried while he was alive, okay? And in the trust, he had a wife. So when he passed away, by the time he was passing away, he and his wife were no longer together. So she was an ex-spouse by the time he passed away, but he had a trust and he had some things he'd already given to his spouse in the trust. But you know what? He did not fund his trust. He did not retitle his house. He did not retitle his bank account. All the stuffs were there. And there was litigation. Why? Because the wife came up and said, you gave me stuffs and I want them. Mm-hmm. They were not going to go to the court process before, but because he's not even put things in the trust and he don't make necessary changes to his trust plan when he divorced, there was litigation. So we want to avoid all those rubbish and mess as much as possible by making sure we fund that trust. If we did not fund his home, that home was going to go to probate. And the kids will be wondering, but our father did a trust, but then they were told your father had a paper, but he did not fund the trust. So, all of you, please have this in mind. When you choose to have a revocable living trust, which is for you to avoid probate or court, make sure you fully fund your living trust. All right? That's when it's going to work, and that's when it's going to avoid probate. Do we understand that? So, so far, we've had about a living trust now. If you think having a living trust for the purpose of avoiding probate is something that you would want for your family or for you, can you check that box? I need a living trust or a will. If you have an estate plan, you want to review your existing plan, please check the green paperwork sheet. I need a living trust or a will, or I want to review my estate plan. Check that, please. And for some people, they want to avoid estate taxes. That can be accomplished also by having a living trust. If you want to eliminate or avoid probate taxes, have a living trust, because those things are not going to pass through the court system, you know. But it's when they pass through the court system that they have to pay on everything. So how can you plan for success in the event of incapacity or in the event of passing away? How can you
Live in trust.
live in trust? We've had a lot of stories of people that have not done it right today, but you can do it right. And now you have an opportunity presented to you. You're learning about how to do it right. So you don't want drama in your family. You know about drama? What's drama about? It could be hilarious. It could be messy. It could be what else?
Comfort.
Conflicting, complex, and all that. You don't want all that to happen.
Daddy likes me more than
What?
you. Daddy likes me more than you.
That it like it wasn't
Contentious.
contentious.
My daughter will say, "Oh no, my daddy is no favorite.
Yeah,
Like
I'm
my two
favorite.
son."
So as much as possible, even if the person is correct, you want to say that in your trust. Do you understand? Rather than let them say be fighting with you. So avoid conflict, do things the right way. Have a living trust and save your family's money and time that way rather than just having a will. Also have a power of attorney and all that stuff that we've spoken about earlier on. So some people ask me a question about I call it asset protection. Like what we're talking about for revocable living trust, it's the primary purpose is avoiding probate. But some people are very, very picky about protecting their assets while they're alive from creditors. Okay? There's another type of trust for that, and it's an irrevocable trust. There's some other tools available with doing estate plans that can do that. But you know what an irrevocable trust is about? While you're alive, you are not the owner, someone else is. And that someone else is the benefactor. Do you understand? But with a revocable living trust, while you are alive, even though it's not in your name, you are the trustee. So it still belongs to you, even though it's not in your name. Okay? So it's a better recommendation than saying the other one, except there's so much need for you to protect your assets against creditors, okay, while you're alive. So we can make it work, and it's easy, and it doesn't have to cost much. Do you want to know more about how we can get this started? we're gonna go there. So today, we've spoken about will, we've spoken about trust. Am I right? I want to know, do you need a trust or a will? Do you need a trust or a will?
A
A
trust.
trust, probably. If you have assets over $50,000, you likely need a trust. If you own a home or a real estate, you may need a trust. If you have special needs kids, you may need a trust. If you have a business, you may need a trust. Okay? So that's why, and it's better for you not to try and DIY when you're having a trust prepared. Use an estate planning attorney. All right? Is this helpful? All right. So the topic today says 3 mistakes people make in estate planning. So can we just, as a recap, tell me the 3 mistakes one mistake from you that you identified?
No planning.
No planning. And how can you avoid it?
Having a plan.
Having a plan. And the other person?
They trust my wife can get all my property. But not when she go get another man though, because I'll be fighting from heaven.
But you can use
Nobody
your
else is
trust.
coming to my wife.
So cool. You can use your trust to control what happens after you go.
Ooh. I would say that if you ever see her with another man, collect the money and give it to my children.
See, and that's cool. You can control what happens to your inheritance after you're gone in a trust.
That's what I'm gonna do, honey.
All right.
If that man is behind you,
All
you're in
right.
trouble.
Any other person?
Yeah.
Do you have anything to say?
I'm not,
We'll still get to the questions. Sorry.
not
Yeah, that's
updating.
Okay, not updating. We'll soon get to your questions.
Awesome.
But we need to get out of in 7 minutes.
Okay.
All right. So thank you very much for sharing those. How can we get started to make sure that we don't leave a mess for our family when we're trying to leave a message in a will or a trust? We're recommending you have it or leave in trust if you have things at stake, okay? We want you to start by having a family wealth planning session. Can someone help me say family wealth planning session? So the family wealth planning session is a 2-hour strategic meeting session where you, if you're married, you come with your spouse, you come to our office, and we will look into details about you, your family, your assets. What will happen? What is best for you? You all probably have an idea of what is best for you. Well, you need to implement it. Am I right? So we go through all that session in the family wealth planning session. Also, you'll be able to make informed and empowered decisions about who you want. In the family wealth planning set to be your agent, in the family wealth planning session, you'll know about levels of planning, and you'll be able to choose a level of plan that is right for you. You will also know how much these plans cost. But I want to assure you that our plans are not hourly fee because we want you to know how much it's going to cost you without surprises. If you go to another lawyer's office, it may be hourly rate. Do you understand? So a phone call or email is going to be costing some money at $400 and something an hour. You won't know how much it's going to be, but we have flat fee. You get to know what it's likely to be or what it is at the family wealth planning session, and you choose the level of planning that is right for you. Also, you will know with certainty that your family will be expertly guided, not only while you're alive, but in the event of incapacity or death. Because we don't just do documents take and go. Do you understand? If you have any questions, you can still come back to us. If you need to review your plan, you can still come back to us. We also get in touch with you from time to time to find out how you're doing. Has anything changed in your life? So you have some form of relationship with us and our office over the years, and also your loved ones can call on us if they have a need to do that. Because we know them. We discussed about who you want to help you out. It should be your agent, it should be your trustee, your successor trustee. and we'll help them when there's a need for it. Do you understand? I had someone, he had his plan done a few years back. His ex-wife passed away. Do you know what? Because he had a relationship with our office, he called all of the, I think the children were trying to call different offices and couldn't get someone to speak with impromptu. But he called our office, and because he's a client, we attended to him and the children. Do you understand? Because we had a relationship with him with respect to his ex-wife's issues. No, not with the ex-wife, do you understand? But we were able to help him and the children whose mothers passed away. So we keep relationship, and we want you to do something. So these are some of the experiences that you have with us. These are some of the experiences that you have in a traditional lawyer's office. So a few of you said you've procrastinated up till today. Am I right? You have an opportunity not to leave your family at risk. Do not procrastinate. If you're thinking about this, we're giving you an opportunity today to stop, to take that next step, and we'll encourage you to do so. So how do you take a next step? We want you to submit this green worksheet. Please add your name and information, and fill it, submit it to us, and when you do, you can schedule a family wealth planning session, okay? When you submit this, we will give you a gift certificate towards the family wealth planning session. A family wealth planning session is valued at $750. So if you did not attend this meeting and you didn't get the certificate, to have that 2-hour meeting with me, you will pay that money. But we want to give this to you at a lesser fee, all right? We'll give this to you when you submit this. Now, take a next step to sign up for a family wealth planning session, and you can do so at the back. My staff will help you to choose a date and a time when you'll come.
We can do our own today now, so that I will sign everything, so that everything
you can do that now. You can pick a date now,
Yeah.
and pick an appointment now, because we see people by appointment.
I think we can come to the house and do it too.
No, I'm not come to the house and do that. We have
So that we can eat it over here. And then
I'll invite you afterwards to eat. Okay. So when you sign up for the family wealth planning session, you're going to get another gift certificate for $250, so that if you retain, or when you retain our services, if you choose a trust plan to do a trust or a wealth plan, you can apply this $250 towards the service you choose. So you're going out with that. But how do we work? When you schedule a family wealth planning session, we're going to get back in touch with you. We're going to send you something in the mail called a pre-meeting packet. Inside the pre-meeting packet, we have of inventory and assessment intake sheet. Okay? That intake sheet, we'd like you to complete it and send it back to us before the date of your meeting. Okay? That is the ticket to get a full $750. Today, when you schedule, please schedule, you're going to schedule with $20. $20 is to put your name and secure your appointment on our calendar. We're very, very busy, and we want serious people. So you schedule your appointment with $20. You can pay with debit card. We have a QR code. You can pay with cash. You can pay with credit card. We'll put your name on the calendar. If you're married, please come with a couple. If you have a decision, come with a spouse, If you're not the decision maker, come with a decision maker, okay? Some people come with their children because they make decisions alongside their children. So if you're married, come with your spouse. If you're not married, come alone, or come with the people that make decisions with you. Schedule with $20. Pick up this, and they're going to give you this and the digital asset checklist, all right? complete your intake and submit before the meeting so that I'll review it and I'll prepare ahead for you so that we'll make the best use of those 2 hours. All right? And then you'll get the 750 credit. You won't have to pay for the session. But if you don't complete your intake, that means you'll pay $730. Am I right? Because you're paying $20, then you pay $730 to have that meeting with me. It's important. It's important to complete the worksheet or the intake sheet. Okay? My staff will tell you more about it when they speak with you or when they send the intake to you. We want to make it as easy as possible. By the time you finish completing that intake, you know what you would have accomplished for yourself?
An outline of all your assets.
Exactly. You'll become more financially organized. And the first step of avoiding your asset from being lost to the government, you would have accomplished that to a very large extent. So it's helping yourself and it's helping us as well. Okay? So how many of us like that or want to make use of this gift certificate? Alrighty, please do. Thank you. So I'll go back at the end. So now, oh, sorry, it's past 12. Oh, we didn't start on time, but let's take 15 more minutes. Is that okay? Is 15 more minutes okay? If we have 15 minutes of questions. Alrighty. So I really appreciate you coming today and airing us out, and I hope you've learned. If you have questions, the ones you've written down and the one that came up, can you ask the questions now? Question time.
The question that I had was, I was thinking, when you're married, instead of marriage, like what we have, the property we have, my wife's name only was there. But when I bought another one in DC, she put her name on it right away. And now that I hear this, I started thinking, God forbid anything happen, which I know is not happening yet. But again, we plan ahead. Nobody knows tomorrow. So I have to go through all these courts because my name was not in that property that I paid the mortgage off. We both paid the mortgage off. So to me, I think that law is not fair because I was thinking the law says that once you are living together, I think maybe that's for the divorce part. If people are divorcing, right? I mean, I don't get
the
it.
law can be complex.
So
but now you clear it.
So now that I know, I want my name in that trust like now.
Yeah.
We are ready for the services. So I want that name there because, it's our property. We both invested in it.
Exactly.
Right from when we were so young. Now we're getting old.
That's true.
So
yeah.
I'm getting old. I ain't no more time.
All right. We'll love to help you.
Yeah, so we're ready for that. So I want that
Thank you
trust
so
as
much.
soon as possible. The next appointment as soon as possible.
All right.
I had a question when you're talking about the living trust. It indicated that if you had designated beneficiaries on like retirement or other plans or whatever, they have to be changed also to be named as part of the living trust.
Okay. Thank you for asking that question. So if you designate beneficiaries, a lot of people designate beneficiaries on life insurance. Am I right?
Life insurance.
And some people do on bank account. All right. The bank account one is called payable and death account, and life insurance and stocks and all that you can designate, and 401ks and all that retirement accounts designate beneficiaries. If you have a beneficiary and the beneficiary is an adult, they get the money. Okay. So that's cool. It's not going to go through probate. All right. However, if the beneficiary is a minor child, because a lot of us put our kids' name as beneficiaries, am I right? Then they're not going to get it. It will have to go through probate. Some other people don't even designate beneficiaries. It will go through probate. So if you want your child to have the proceeds of a life insurance and the child is a minor, then having a living trust will help resolve that issue.
No, I'm talking about in terms of establishing the fully funded living trust.
Yeah.
That was one of the elements on it.
Yes.
So if you have a designated beneficiary,
Beneficiary.
you don't have to include it in the living trust because they're gonna get it.
Exactly.
Okay,
You don't, but we want to make sure that you designate the beneficiary.
right.
We have people come to us, I have life insurance, but I don't even know who the beneficiary is anymore. So part of the process is us making sure you go find out who that beneficiary is. And if it's still the person you want, do you understand? Then you leave it. But if it's not the person you want, then you have to make a change. I know someone whose spouse was a beneficiary and they've been divorced for 5 years and the spouse is still there as a beneficiary. And that wasn't like a settlement agreement. She just forgot about it. If something happens to her, who's going to get that money? The ex-spouse. But does she really want to give it to the ex-spouse at this point in time?
Well, the spouse supported have paid all the money, why not? And if they have children together.
Now they're not in good terms.
Well, I mean, for me, God forbid anything happen, my wife takes everything. Because I have 3 children, I know she look out for my children.
Exactly.
To any new
But what if they didn't have children?
That want to come and eat
What if
where
they
they
didn't
didn't
have
sit.
children? Do you understand? So what's your
It's
question?
actually presented to her question.
Mhm.
Because my question was, I know you said transfer the trust, like let's say a bank account, you transfer that name instead of like my name, it would be the trust name.
Yes.
What's the difference of let's say you have an account and the beneficiary is the trust? Does it matter?
If you have an account and the beneficiary is a trust.
Right.
You establish the account
Yeah.
after you establish the bank account after you just establish the trust.
Yeah.
Other way, you already have a bank account and then you're making a trust now. And
Oh, then you have to add it to the trust.
So you have to add it to. So if you have to have a trust for a beneficiary to be a trust. Am I right?
Correct.
Okay. So if you have a bank account, usually what we see usually is that a bank account is in the person's personal name.
Right.
Okay. So when you have a trust, you now change the account name title to the trust name, and you are the trustee.
Okay.
Okay. So you still manage that account, and you are the trustee. You'll also be the beneficiary.
Mm-hmm.
So the account is still used technically, apart from the title,
Mm-hmm.
which is now in the name of the trust that protects it from going through probate. I don't know if I answered your question. Can you say the question again?
It's almost like the investment account, how they'll have like the beneficiary of the account will be a trust.
Mm-hmm.
Because I know I was told that when you have like certain bank accounts, like and they have dividends, you have to pay state tax or trust taxes on that money. So
Okay.
it's like a weird thing.
No, so when they say trust in the investment account failed,
Mhm.
maybe they've been administrator of the retirement account. Is that what you're saying? As in, who is the like Fidelity, Vanguard? You know, those are the popular ones. That's what they refer to. Is that what you're saying?
Yeah, it's like the parents will say, let's say Johnson. You know, Johnson will have a brokerage account, and then their benefits would be Johnson Family Trust.
Okay, that means they already had a trust.
Okay.
Yeah. So if something happens to them, so let's say the parents are Johnson, they got a Johnson Family Trust, the beneficiary is Johnson Family Trust. That's a good way. If you have a minor child, it's one of the solutions we propose.
Mm-hmm.
Because if the parents pass away and the children are still minors, the benefit goes to the trust name, and in that family trust, there are specific instructions of how that money should be taken care of.
Okay. And I think for that one, I think it's like an IRA, and you can't put like IRAs in the trust or something like that.
You don't necessarily have to do that
Okay.
because they're payable to beneficiaries.
Okay.
Do you understand? But you can put a trust as a beneficiary as well.
Okay.
Okay.
I have a question about keeping your loved ones away from predators. What type of predators are we talking about? Are we talking about if the person who dies had a debt, or are you talking about things that just come up along the way, like fees and lawyers, and in what instance would you say, okay, I need to keep my family away from predators?
Okay. So what comes to my mind is this. First of all, if you own a mortgage, you still have to pay your mortgage, or someone will still have to pay that mortgage for you, but a mortgage company is a creditor. But for example, I give the example of someone that, estate sales people, those who sell estate property. Am I right?
Mhm.
They could go to the probate court and see what's going on, and then approach your beneficiaries and say, hey, I want to buy your house for maybe $60,000 instead of $200,000. Business owners can come that way. But if you have creditors like credit card companies, um, whatever goes to your beneficiaries, let's say they came in as they got their stocks as maybe 19, 20, 21, and someone knows that they got a lot of money somewhere, then they can sell credit cards to them. Do you understand? Another situation that came to my mind is someone had a house floored, as in flood, FLOOD, and he got some inheritance money, okay? But the insurance company thought it was at fault, so the insurance did not pay it, and at the end of the day, deep pockets came in, and the insurance company had to sue him to get some money back from him because they knew he had money in his account. You know what is called garnishment and things like that. Okay. But when you look at creditors, really, it may not be you. It's usually your beneficiaries that get a hit of it. Okay. Did I answer the question?
Yes.
All right. Do you have any questions?
Yes, I have a question. So what's the difference between having a power of attorney versus guardianship?
A power of attorney is used for, it's proactive. Okay, so you have it prepared. It's a legal document that you prepare proactively, and you name who your agent or power of attorney agent is. It could be 1, 2, 3, or however you want it, and when you want it to be effective. If you have that in place, you avoid guardianship because the agents now act on your behalf instead of the judge choosing a guardian for you. The agent is the guardian. It's just the terminology that is different.
Mm-hmm.
The judge chooses an agent, now called a guardian, for you if you don't have a power of attorney and you're incapacitated. Okay, that clear? But if you're proactive, you have a power of attorney where you choose that person yourself to act on your behalf. All right, did I cover all the questions?
I just have one comment to make about the
Okay.
life insurance stuff. My sister recently died, and she left, all of her stuff is to her 2 sons. And one of them has a PhD, and the other one is incarcerated. So everything was joint, life insurance joint, So the incarcerated one refused to sign off on anything, the life insurance or anything like that. So and I was thinking that, they would at least take the burial expenses out or something like that. They couldn't do any of that when you have it set up like that. So they had to, even though she had substantial amount of insurance, none of that could be accessed because there was not the agreement between the two. So we had to come out of pocket to pay for those services, even though she had $150,000 in insurance.
Yeah, that can happen. So sometimes we advise they don't choose joint agents,
Do separate.
particularly if you know your kids, to separate. So thank you so much, everybody, for coming here today. Thank you for participating. I hope you learned a lot. I hope this is helpful. Please take the next step and let's, as staff, help you schedule a family wealth planning session. If you know someone that needs the service, please send them to call our office. We'll be glad to help them. If it's
Once I
you,
send a customer, I get my referral fee.
we'll give you a gift. We'll give you something, and we'll give them something
Okay.
to help them. We'll leave you catered for. Okay. So thank you so much, everybody, for coming. Sign up, and we'll help you, help your family. God bless. Thank you for those who are online. We'll be signing off now.